Our first speaker will be Brian Camilio, founder and CEO of ArtistShare. He'll be followed by Professor Sean Pager from Michigan State University School of Law. Then we'll hear from Professor Sean O'Connor from the University of Washington School of Law, and lastly from Ron Katz-Nelson, president of Bi-Level Technologies. And they'll be talking about the importance of intellectual property to creative upstarts and startup firms. Each speaker will have 15 minutes to present, and then we'll have some Q&A and some interaction among panelists. So without further ado, Brian, take it away.
Okay, great, thank you. Good morning, everybody. My name is Brian Camilio, and I am the founder and CEO of ArtistShare. Just to let you know, I'm not an attorney. I'll let you know, you'll know a little bit more about me by the end of this presentation, but I have to say that so far this conference has been just an invaluable resource for me. These days I'm mainly an inventor and a business owner. I founded ArtistShare in 2000. I currently hold a patent on my business system and process, and I have additional patents pending. I'll get into a little bit more about what ArtistShare is, but I think it's more important if I start with a history of me. Actually, that's the wrong slide. Hold on. Okay. Well, we're not going to start with me. We're gonna the initial point that I want to make is that I'm both an innovator and an artist. To me, innovation and creativity are the exact same thing. There's no difference between the two things. A few years ago, I started hearing things about something about creators' rights, being a block to innovation, and people hold intellectual property, holding up whatever ventures that were happening, and I just don't understand that viewpoint, and I don't understand it legally, but I just don't understand it, because what is the let's go over my history. That'll give you something to frame this with. I'm a musician. I started playing music when I was about 8 years old. I studied music. I went to music school. I was really influenced by the music of the 70s, and one day I was in my grandmother's driveway and I heard Stevie Wonder on the radio, and that was it. It was white light experience for me. I was like, I have to be able to do that. I need to be able to do that. And from there, there was no brainer. I was going to be a musician. That was it. Okay, so at a very young age, I had a passion for music. I've created a graphic of my timeline as a musician. Starting at age 8, I bought my first guitar. I loved playing the guitar. That's all I wanted to do. I got a job as a car washer in my neighborhood to pay for my first guitar. I also got a job as a paper boy so I could pay for my guitar lessons. And that's what my parents made me do that. My first electric guitar was $20. And then my father gave me $5. He said, you have to make the other 15. So from a very early age, I started working hard at my passion. By age 11, I had formed a band. And I was still working as a paper boy. And I actually wrote my first song at age 11. It was called Sandman. And to this day, I haven't heard anybody else play anything like it. It had 2 chords. It went from D major to C major. And my friend Bill wrote the lyrics. But, the thing is, it's true. I haven't heard anybody copy that song or play that song. It was a very unique expression. And one of the things that, one of my points of this is that creativity is like a fingerprint. You can have something that's similar, but it's never going to be exactly the same if it's a true creation. It's just the way, this is the way the creativity works, as far as I'm concerned. Okay, so moving forward, I'm pursuing my passion for music. I'm playing in bands. I'm working jobs to make a living, and I'm putting myself through school. I'm getting a degree in classical composition, because by this point, I'm just so deep into music. I'm just going on, going for all sorts of things. I'm performing regularly, and I'm working as a bartender, and I'm also working as a behavioral test subject for the effects of caffeine, which is, just that's par for the course for if you want to be a musician. All right, you're going to have a ton of really weird jobs, just in order to be able to, continue doing what you're doing. By age 25, I wrote my first orchestra piece. I'd written 3 string quartets. I got a commission for a large piece. I was doing lots of gigs. I got so many gigs in Japan that I actually moved to Japan. And I went there, got an apartment there, and I was playing regularly. Before I moved to Japan, though, I still had my job as the chicken wing delivery guy. And I had to wear a hat with wings on it and drive a Volkswagen Bug that had been tricked out to look like a chicken. I'm 25 years old. But I don't care, because I'm playing music, living my dream, no problem. So fast forward a little bit more, age 30, I'm working as a bartender. I get a position as an adjunct faculty member at the New School in Manhattan. I wrote a music tech book, basically on how to use the software Finale, which is a music notation software. Of course, I copyrighted that book. I would copyright all my music that I was writing. I was very well aware of the value of copyright and intellectual property, because that's how we musicians and authors, got paid. I'm an author now. And I moved to New York City, and I was playing all the time. I was doing really well. Okay, now by age 34, I am a rock star. I am just, I'm doing everything I ever wanted to do. I'm living in Manhattan. I'm touring around the world. I'm teaching. I'm writing music for TV. I'm making a pretty darn good living as a musician. All right, doing really well. I'm studying with my mentor, this guitar player named Jim Hall, jazz guitar player. It was just, I'm producing records with him. I'm having a great time, okay? Then I had an idea. And that's when the problem started. I had the idea for my company, Artist Share. And as you see, I turned into the little monkey saying, uh-oh. Okay, so what happened next? This was 1999. This is when Napster was becoming very popular. And if you all remember Napster, it was file sharing and digital downloading, and it was really wreaking havoc in the music industry. At this point in time, I was also intensely interested in technology and computers, and I was teaching myself how to program. Now, it was very natural for me to learn how to code, because it was exactly like writing music. It's just a language, you take it, it's a finite language, you put it together creatively in order to have it do something you want to do. It became my second passion. So I sat on the floor of Barnes & Noble, read books, went on the internet, taught myself how to program, and I got really into this, and I realized, boy, this is going to be a problem, this whole digitization of commodities. This whole thing, the end result of music being digitized and being able to be shared is going to be a real problem, because technology is going to move fast. So I started really worrying about the future of music and what would happen. At this point in time, my friends in New York were some of the greatest musicians in the world. And I was really concerned about how they would continue to make music. So I saw an opportunity here. And I didn't decide at first. I had the idea for Artist Share. And Artist Share, basically, the idea was to flip the model. Since artists or musicians would be writing music, as soon as they released it, they run the risk of it just, going off into the ether and never getting paid. I decided to create a model where the artists got paid before they released the music. Simple enough, right? Just make sure they get paid, just job security for the artist. And so it really got me thinking philosophically, what is the real value of music? And to me, the value of music is the creative process by which music is created. The creative process is a timeline, and all these things that we were consuming as music fans were just snapshots of that timeline. A couple of days in the studio this year, a live performance this year, press the vinyl, press the CD. You're just getting snapshots of this process. So I said, well, the real value is in the process. How do we monetize the process? Well, the internet is a great vehicle for being able to relay the process. Relay a timeline of events, stream video, stream audio. Well, video was like a postage stamp then. Stream audio, send pictures, download files, and basically tell a story and have people subscribe to that story. And therefore, the music gets funded. And then when it's released, and everybody in the world puts it up on Napster, and no, the musician doesn't make another dime, it's okay, because they already got paid. And also, why don't we have the super fan? Well, if they put in $10,000, they can come to the recording studio and watch, you know, and witness as this is happening. That's what the artist share model became. Luckily, I had enough experience with copyright to know that I needed to protect my ideas. And if I was gonna start a business, I was basically giving up the last 26 years of my life to start something new. All right, so I was gonna make sure that I was protected about this. So I filed for patent, and I bootstrapped my business. I took all my savings, and I built the entire thing myself, including setting up all the servers, running them out of my apartment in Manhattan, which my landlord didn't care for. So people say, well, Brian, what did you do that for? That's crazy. You spent your whole passion from the time you were 8 years old until you were 34 years old was music and playing music and writing music. Why did you do this? The answer is, I don't know. I have no idea why I did this. I had to do it. I had this idea, and I had to do it. I knew it was right. I knew it would be successful. I knew it had to be done. So I took one for the team, and I did it. Okay, so I launched this site. It took me 3 years to build it, did all my intellectual property. Launched it in 2003. We became the first site on the internet for what we were calling fan funding, creative projects. Our first project that was funded by the fans won a Grammy Award, and it was by composer Maria Schneider, and it was the first recording in history to win a Grammy without being in retail stores. To date, we've won 9 Grammy Awards and got 18 Grammy nominations. I work with about 20 artists. We pioneered the industry, which is now, as of 2006, called crowdfunding. This was the first crowdfunding model on the internet. In February 2011, my patent issued. Now, mind you, I filed for this patent in 2002. All right, it was 9 years of prosecution for this patent, but we got it. You know, it's a good patent, you know. And in October 2013, we celebrated our 10-year anniversary in business. So it was a success. The business was a success. So that being said, what is my relationship to IP as an inventor and as an artist? Well, I made a little map here with some colors on it. It looks like it's a little bit, didn't quite print very well, but you get the point. Basically, the purple is other people's IP that I was dependent on in order to execute my art. Okay, when I was a kid, I bought an electric guitar. There's a lot of IP involved there. The electric guitar would not have existed unless somebody had built it and they patented it and they had an incentive to get it going. And I built my whole career on that, on the electric guitar, other people's IP. I was delivering papers as a boy, right? Paper is not, you're not paying for the paper when you buy a paper. You're paying for the information on the paper. It's intellectual property. My first gig, I was 11 years old. We got paid in brownies, and we played 3 Kiss cover tunes, and we debuted Sandman. When I was 21, I was doing regular performances. I was earning a degree in music. I was working as a behavioral test subject, all IP-based. I was dependent on other people's IP to make a living and to use my art. By the time I was 25, I started to really create my own IP. I wrote an orchestra piece. Right? As soon as I wrote it, copyright symbol on it, it's copyrighted. I wrote a book. I copyrighted that book. I was an adjunct professor at the New School. That's intellectual property. Basically, everything that I ever did is so incredibly dependent on intellectual property That without this creative intellectual property protection, I wouldn't have been able to do anything in my career. It just wouldn't have rolled out that way, okay? So it was crucial every step of the way, as you can see. Okay, in conclusion, my opinion, my humble opinion as an inventor, as an artist, the creative industries and innovation industries are not inevitably and irreconcilably in conflict as some people would like you to believe. I'm living proof of it. I'm both, all right? And it's essential for both. And they have to work together because they're the same thing. You know, the creative industry and the innovation industry is the same thing. Writing code is just like writing music, is just as creative, is just as innovative. What creates obstacles are people and companies who do not respect the other's rights and try to circumvent them. That's what stymies innovation, all right? That's what causes problems. The true story of innovation and creativity is a virtuous circle. That was part of the description, and I thought that really summed it up very nicely. And I would like to end with a picture of Greetings from Walpole, Mass., 1976, my band, Amethyst. Thank you very much.
Thanks, Brian. So next up, we have Professor Sean Pager.
All right, so good morning. I'm a law professor, and I'd like to start this talk in the time-honored manner of my kind with a law school hypothetical. So imagine you're a singer in a rock band. Well, I guess, Brian, you don't have to imagine.
Okay.
But imagine you're just starting out, okay? And you're working hard. You're trying to playing the gigs, trying to get that big break. And one day, you're listening to the radio, and you're thrilled to hear them play one of your songs. That is for a minute, and then excitement turns to anger because you realize your song is part of a car commercial. So you never authorized this, and you call up the dealership and protest, and they just brush you off and tell you you should be grateful to get the free publicity for your music. So what do? You can't afford a lawyer, and even if you could, the cost of litigating this case in federal court is going to dwarf any license fee you might recover. You can't file, by the way, in state small claims court because federal exclusive jurisdiction for copyright. And what's more, you never registered this song, so you're not eligible for statutory fees or attorney's fees, statutory damages or attorney's fees. So you're basically out of luck and frustrated at your lack of recourse. You decide you're going to quit music and go to law school. Okay, so what's the point of this silly story? The point is, we tell this story about another story, a bigger story about intellectual property rights and copyright specifically. But the story is we give these rights to authors and artists to encourage them to create and commercialize their work. The flaw in this account, though, is that rights are not self-executing. If you don't have the capacity to use your rights and take advantage of the options they make available, then the rights aren't really doing the works that we want them to. Okay, so the problem for creative upstarts, example like a startup musician, is that we have a system by design or default. We've designed our copyright system, engineered it in a way that systematically disadvantages those who lack information and resources. So the law itself is technically complex. Simply to answer the basic question often requires an incredibly convoluted analysis. I tell my students this is a good thing because it's Full Employment Act for them, but I pity the authors and artists who are trying to struggle, often without the benefit of counsel. It's not just the law. It's also the formal law itself is embedded within a complex set of institutions that follow their own arcane logic. So in my initial story, I highlighted the importance of registration. Our musician would have been much better off if he'd registered his work with the Copyright Office. And in fact, it turns out it's pretty cheap and easy to do that. You can do it online. You don't need a lawyer. But that's only if you know that. And a lot of musicians, like Brian, don't realize the importance of registering their work or think it's too expensive to do it. And registering with the Copyright Office is just the start of things you might want to think about. If you're a musician, you also want to be with a PRO, sign up for ASCAP or BMI, and then there's Sound Exchange, and you have to know which of your works belong with which rights with which organization, and that's not necessarily a simple thing. If you've done cover tunes or original material, there are differences, and a little tough to keep track of. And then there are the purely private registries, like Google Content ID. You want to be there, maybe some other places. So that's a lot for someone just starting out to think about, all these different steps they need to take to secure their rights. And this is just registration, right? I could go right down the line through the copyright system and talk about clearance, licensing, enforcement. All these different things require some sort of sophistication. And if you don't have that, you may be missing out. Okay, so I think you can see how this is a problem for some musicians and other creative upstarts who are starting out. But why should we be concerned, the rest of us? Why is this a problem for society? Well, it goes back to the question of what is the copyright system designed to do? Who is it for? Copyright is not just a system of economic regulation like any other, where the goal is efficiency or wealth maximization. Right? Copyright is here for a very specific purpose, and its mission statement is right there in the Constitution. We give copyright to further progress in the science, useful arts. In other words, we're supposed to be fostering innovation. That's the goal. Okay, so if our goal is innovation, we might ask, who are the innovators? Who are these people who are trying to encourage with our copyright? Well, maybe back in the 20th century, mid-20th century, when the Copyright Act that we have today was being written, you could assume that anybody involved in this business was a large, sophisticated entity, right? Because content creation back then was a big capital-intensive business, and the actors were largely, insiders who were well-resourced, had lawyers, access to counsel, lots of administrative abilities, capabilities. And so you could assume that anybody in it who's doing anything of value was either one of these big entities, or they are signed or under contract or represented by somebody who was hooked into the system. But that's simply not true today. Right? We live in a world of digital technologies, and tell this wonderful story about how we have these new tools that have emancipated artists and lowered barriers to entry, democratized the production and distribution of content. Right? So anybody can create something in their basement and send it around the world. And there are a lot more people out there who are boldly braving this new world of disintermediarization. You have artists, musicians, indie filmmakers, web app designers, graphic artists, all kinds of people out there who are on their own. And they're struggling to make it, but we should care a little bit about whether they have a chance to succeed and whether the copyright system is helping them. Now, why do I say that? It's because these creative upstarts fill a vital niche in our creative ecology. Big content is gradually focusing ever more myopically on serving the mass market. They're just reworking tired formulas to make their blockbusters. And it's the upstarts who are the ones who are free to take the chances, to really experiment and take the risks. And we've seen time and time again that the real creative innovations often start on the margins and only later make their way into the mainstream. So all of this is to say is that if the copyright system is not designed with the interests of creative upstarts, maybe it should be. Okay, so if you buy my account and you think we should care a little more, maybe take some common steps to make things easier, what would that involve? Well, there's a long list of things I could go through and don't really have time, but suffice to say, we have to start by thinking and taking transaction costs a lot more seriously, right? Because for artists starting out, what's really not important as much as the strength of your rights or how long they last, it's the ease of using them. So in terms of substantive law, anything you can do that's going to reduce complexity and promote legal certainty, that's got to help. In procedural terms, we need cheaper, more efficient, lower cost enforcement mechanisms. And here, finally, the Copyright Office has come up with a proposal for small claims dispute resolution for copyright. It's voluntary, so it's not a total solution, but at least it's a start. And then there's technology, and perhaps this is the most promising note I can end to is a vision for the future. So I mentioned the problem with registration. We have all these different registries, public and private, to keep track of, a lot of different forms to fill out. Well, what if we simplified that complexity using software, right? Using a computer tool that could make a single interoperable network platform, so you'd enter your information in one place, doesn't matter where, any registry, and it would automatically share that information with all the other registries. That would be a nice start. And we could do that. The technology is available. And ideally, we would layer on top of that a nice computerized expert system interface that would guide artists through the choices so they'd know what their options are and could make informed decisions. We do these things. So I can give you an example of how this might work by making an analogy to another area of daunting complexity. Think of the tax system. Right? Think how much of a hassle it used to be to fill out your tax schedule, and still a hassle, of course, no one likes it, but think how much easier a program like TurboTax has made filling out your tax return, right? Because it can take you through step-by-step all these schedules and cue you and prompt you to remember to fill in this and fill in that so you don't miss out. Well, maybe we need a TurboTax for copyright. Maybe we can go further. Maybe we can think about licensing and enforcement. Maybe, Travelocity or Kayak or all these other tools out there, right, that we could take by analogy and make them work. Well, lots of bright ideas, and some of this is expensive. It can take some determination. But I think there's some real value in pursuing this. And the value, I guess, is, one, fulfilling the mission statement of copyright innovation. But there's some other payoffs. And I would suggest, some of the payoffs also might be reshaping public perceptions about copyright. So, like it or not, we have this opponents of copyright are numerous, and a lot of them have been pushing forward this story that copyright is only about making rich media moguls, entrenching monopolies. Right? It's not about anybody else. Artists and authors are just as screwed as anybody. So, copyright is just for the 1%ers. Well, that's a false portrait of how the copyright system, and Brian's account sort of illustrates that from the ground. And but that myth is out there, and I think it has a lot of credence. In fact, here I could contrast the copyright system, kind of in the spirit of this conference, Common Ground. I could point to the patent system by comparison, where in patent, we do have this lore of the garage inventor thinking of the great next big thing, and that's taken seriously in the popular imagination. It continues to have its grip, and also in patent debates. The plight of the small inventor resonates. You saw this in the AIA debate about shifting from first to invent to first to file. People really, at least rhetorically, pointed to and spent some time debating about whether this is really going to disadvantage the small guy. And even the patent office itself is it's not just rhetoric. For many years, they've had a fee scaling where they give a 50% discount to small entities. So, those are some simple things we could learn from and maybe try to make the copyright system kind of refocus. But to do that, we have to, I think, there is some truth to this story right now that copyright is mostly benefiting successful artists and authors and not so much the little guys. And maybe we need to take some steps to change that narrative. Okay? By giving a fairer shake to creative artists, copyright supporters would not only enlist a much broader set of stakeholders that are vested in the system, but we would also have the potential to fundamentally alter the terms in which the copyright debate in the future is waged. Thank you.
Thank you, Sean. And next up, another Sean, Professor Sean O'Connor.
All right, thank you. Thanks for having me here. I always love coming to CPIP events. I'm a frequent flyer with CPIP, and always happy to join.
We love having you, Sean.
Yeah, so I am the other Sean, and also, like Brian, played music for quite a while, but then, unlike Brian, I dropped out, sold out, went to law school, sadly. But I have to say, I think I got my first Mustang, an old used Mustang, from somebody in Walpole.
No kidding.
So we'll talk about that later. We can talk about that now, but that's probably not a great use of everyone's time. Okay, so what I want to talk about today is appropriation and innovators and creators, okay? And so here's a quick overview of the few themes that I'm going to go through, okay? Like many others that have been speaking, including Brian and Sean today, and I think Richard yesterday, that this creators versus innovators is just a false dichotomy, and it's being used by a lot of folks out there rhetorically for very particular ends, okay? Second thing is I'm going to then start talking about what I mean by appropriation mechanisms, and I'm going to kind of break or go outside of the construct a little bit, and then I want to point out that there's lots of different appropriation mechanisms beyond formal IP, or what we think of as formal IP, and that's important because everyone is using some kind of appropriation mechanism, okay? You don't do businesses, you don't do any kind of investment unless there's some way of appropriating returns. And then the final thing is that once you move from that, understanding that, you understand that what's really going on rhetorically out there is that a lot of folks want free inputs to their business model, but they want to propertize their outputs. I get that. That makes a lot of sense. But what's going on is a bit of a shell game in diminishing, as Brian was saying too, diminishing some folks' appropriation mechanisms and highly valuing their own. Okay, so a lot of this has been said, so I'll just go through the slide fairly quickly. But I think, as again Brian pointed out, what is a creator that's not also an innovator? Okay, I think what happens is that people are really the folks who are trying to get rhetorical mileage out of this creator versus innovator are really trying to position artists against entrepreneurs. Okay. But the problem is if you just use the word artist or just entrepreneur, both of them don't really get us where we want to go with this innovation or creativity part, because there are artists, just like there are entrepreneurs, who can really be just replicative. On the entrepreneurial side, we often think about entrepreneurs as always the tech startup, but of course if you do business school, management school kind of studies, that a lot of the focus there on entrepreneurship is just on regular, small, kind of Me Too businesses. Somebody opens a new dry cleaner, new pizza shop, whatever. There's still something creative there, but it's not what we're normally thinking of. So entrepreneur, right, can be a term that includes a lot more than what we mean by creativity and innovation. And similarly on the artist side, there are sadly quite a lot of artists, in fact some that make it quite big, who really are not contributing anything particularly novel, but they have a certain look or whatever, and so they become quite famous perhaps, okay? Okay, what's the core thing going on here? Well, for me, it's that both are using genius and skill. And I have that in quotes just because that's a term that you'll find if you look at a lot of the earlier court cases talking about both copyright, well, not at the same time, but a copyright case and a patent case. Because these notions of genius and skill, genius is the kind of insight. We don't really know where it comes from, so it's not Einstein IQ genius. It's really the earlier sense of genius, which is you're inspired. We don't know where it comes from, but you have some kind of vision. That's as equally true for a great kind of innovator entrepreneur as it is for an artist. The skill part is equally important. Notice Brian's story. Unlike me, he went to school and learned music for real. I was just all self-taught, right? Because he knew that that's what you really, really need to do. So the skill part is equally important. Why? Because it allows people to better execute on their inspiration, okay? If you don't have that formal training, you may have a lot of good inspiration, but you won't get the execution. Okay, why is the execution and the skill part important? Well, because that's really what the IP systems, I think, are trying to incentivize. They're trying to get people to move beyond that first kind of aha thought and to actually have the skill and deploy the skill and get the resources together to give us a finished kind of product. Okay? Again, like Brian was saying, this thing about the creative process is really where the action is happening. The song at the end, the recorded version, is just indeed that snapshot. It's just one moment in time. There's a lot more going on. Okay. Now, let's talk a little bit about appropriation mechanisms. Okay? So it's not just patents or copyright, but it's really any means of getting exclusivity over valuable assets. The example I have up here is data exclusivity or first generic exclusivity under Hatch-Waxman. Okay? It's sort of derived, or it seems patent-like, but particularly the data part is not necessarily patents at all. also in Brian's example about being a paper boy, a lot of us who do formal copyright know that things like the INS case get it a kind of misappropriation for hot news. So in fact, we all know that the lawyers in the room know that there are things on the fringes outside of formal IP that in fact can be valuable, at least temporary appropriation mechanisms. Once we broaden our scope, we realize that, okay, and at least in my experience, I've been a practicing lawyer for a long time, continue to practice on the side of my law professor job, and I haven't run across any clients that don't have some angle by which they're appropriating, okay, a return on their investment, whether the investment is money, time, whatever it is. You just simply don't do it, okay? Now, what's the problem? Well, the problem is that a lot of the so-called empirical research that's going on out there, especially in the legal academy, is artificially focused on one appropriation mechanism at a time. And that's probably not accidental, okay? So you can look at a particular industry or particular area, and you can say, well, copyright's supposed to be important for that, or patent's supposed to be important for that. At least that's the story. And so if I can go in and find a bunch of examples where people in that industry were doing that, acting in that area without getting patent protection or didn't have patent protection available, then I can blow up the IP story and say, see, aha, IP's not important. But notice the move, moving from siloed focus, all right, for this particular set of people, they weren't using patents, therefore IP is not important. Okay, that's just simply not true. What you have to do is focus on, are they using some other appropriation mechanism, okay? All right, so what happens next in thinking about appropriation and why this battle is raging right now? Well, it's inputs and outputs, okay? As we live in a more and more sophisticated and complex society, everyone is using everyone else's stuff, okay? Right, there are still some things where we actually, get stuff, extract stuff out of the ground, and then we make objects, like we're talking about PET plastics, or now vanilla, right, being a way to make plastics, okay? But a lot of what folks do now to make money is to take somebody else's output, somebody else's processed stuff, and then use it as an input to theirs. Okay? Well, if you look at this from a financial or business perspective, of course you want your inputs to be as cheap as possible and, have a high margin on your outputs. So that then plays hand in hand with this essentially a shell game about whose IP is important or whose appropriation mechanisms are important and whose are not. So you really want to focus on my appropriation mechanisms, whatever they are of course incredibly important. The other guys are not. So Brian's songs, when he puts them out there, if I'm somebody who is, doing stuff on the web to sort of send content down the pipes, his stuff is not really that important. But my code for running my, digital algorithms for my search system or whatever are incredibly important. And I'm not really using, I'm not using patents, let's say. So I'm kind of hiding the fact that I'm still using an appropriation mechanism, okay? Now, an example of this inputs and outputs, and I'm going to give an example of how the shell game really works. A direct view of inputs and outputs is what's called appropriation art. There actually is, some of you are probably aware of it. It's the things that have been litigated by Richard Prince, okay, the Carrier versus Prince case, where basically artists really do take somebody else's artistry, photographs, whatever, and then change them a bit, arguably, and put them into their own new artistic work. That's a very direct appropriation, okay, where they're literally taking somebody else's output and under the same mechanism, copyright, are reusing it. That's fine. Well, it's not fine that they do that, but the point is that it's easier to see what the debate is about whether this input, should be propertized or not. But it's when you move to categorically different inputs and outputs. So again, shift from this to the story where you have somebody else's content, songs, movies, and now somebody else is doing code, and they're basically then saying, okay, just ignore the fact about that I have appropriation on my IP. That's important, and of course we're not going to disrupt that, but the other person's appropriation mechanism is simply not important. Okay, so let me just, in the interest of time here, basically get it, thanks. why we have formal IP, okay? So we have these broader appropriation mechanisms. And so you might respond to my comments today and say, well, okay, I understand that, but so if people have different kinds of appropriation mechanisms, just let them use them. Maybe copyright doesn't work anymore, so we can just get rid of it. They'll use some other appropriation mechanism. The reason why, in my opinion, though, we've developed over quite a period of time now formal statutory-based copyright and patent systems is that there are a lot of things we can try to get at and appropriate through, say, common law, through property, contract, and tort. But sometimes it just becomes too burdensome. It's too hard to make the case for it. We know something bad happened. We know something was misappropriated. But it can just be difficult, okay? Or there's a scienter requirement, or there's things that are too high. And so we decide as a society that we'll create essentially a streamlined system for somebody to then be able to show what their property rights are and then enforce them. And so I'll give you a little bit of an analogy that's way outside of IP, but I also teach corporate and securities law. And securities law, I believe, followed that same path. What are we doing when we have federal securities law? We're really going after fraud. Well, but you can get at fraud under tort, under common law. So I always ask my students every year in the securities law class, why do we have a statutory security system at all? We can get at it through common law principles. We do that because it's quite hard to actually capture people and to show the scienter, get the so-called smoking gun memo, where somebody in the company says, yes, we intentionally lied about something going on in the company so it would inflate our stock price, or it wouldn't cause our stock price to crash. So instead we create this disclosure mechanism. You have to disclose. If you do anything misleading in the disclosure, then you have liability. Copyright and patent work, in my opinion, quite similarly. They give you a statutory basis, a clearer construct by which people can go about showing the valuable assets that they have. And rather than having to always rely on these other kind of ad hoc appropriation mechanisms, they can instead use these statutory mechanisms. And let me leave you then with the most disturbing episode of this rhetoric that I found, and some of you who are on IP profs probably remember this from about 6 months or so ago. It was proposed on this listserv that, well, you know, it's actually a good thing when some of these older artists, like Leonard Cohen, in fact, got defrauded or had other bad things happen, because, you know what, it made them come out of their cushy retirement and have to make new music. Well, you know, I get that at one level, right? If you're thinking in the abstract, it seems, well, why should somebody be able to retire early and not use their valuable genius and skill again for the betterment of humankind? But I responded on that list, and I think I only got responded back was the sound of crickets chirping. But they said, well, that should apply equally to tech founders. And I'm not trying to get against tech founders, but it's the same story, right? Many of them have their, you know, they often have a couple of startups, but they have one that hits really big. And up in Seattle, where I live, we have this place called the Methow Valley, which is this great kind of ski area. It's awesome. And the story in Seattle is like, well, some of these guys go to the Methow Valley and basically retire. And everyone wants to lure them back out of retirement because a serial entrepreneur is a very valuable thing. But where's the dialogue about that? Why are we not saying, well, they earn too much? They earn too much, so they should come back out of retirement. So the bottom line with this is that there's a big shell game going on. There's lots of different appropriation mechanisms. Some of them are more efficient than others. Okay? We should, in fact, encourage people to channel into the statutory ones just because we can all have a better sense of efficiency. Efficiency in this way, not about whether they should have property rights or not, but efficiency about so we can document their property rights. Brian went through and got his copyrights registered, okay? His songs registered. Then we can know what we're talking about, have a system by which we adjudicate this. But don't let people fool you that just because they are not using one particular kind of appropriation mechanism, that instead they are giving up any appropriation mechanism. We all need them for anything we do when we try to operate in the world, collect resources so that we can do useful things. Thank you.
Thanks, Sean. So last but certainly not least, we have Ron Katz-Nelson.
Thank you. I want to thank you, CPIP, for inviting me here again to speak. about my experience and some of the lessons learned as I was moving forward through some of the entrepreneurial paths. So talk today about my lessons from technology startup and how we navigated the ever-changing patent system. I'm an inventor, got 23 U.S. patents to my name, technology entrepreneur, and an advocate for the patent system. And the advocacy comes from the experiences I've had, which I'll describe. Prior startup, before the second startup I'm on today, is going to be the topic of my discussion about a unique system in the patent system that we have is called the continuation application, which really saved the startup of my previous startup. And I'll talk about how that happens and what the lessons are from that. Specifically, how this very unique feature for the U.S. patent system, continuations and requests for continued examinations, are critical, and it's unique to the U.S. case. Broadband Innovations, Inc. is my prior company, the startup, which really got a second lease of life because of those specific features of the U.S. patent system. Series A funding was in 1994 when I got Ameritech, the baby bell from Chicago, to invest in a new technology. That was not a venture capital investment, that was really a strategic investor. And developed a multi-channel cable TV point-of-entry device on the side of the house to control access for television for your TV, your VCRs, cable ready equipment, so you wouldn't have to have a set-top and watch and record problems and so on. Phone companies really like that point-of-entry device to control multi-channel simultaneously entering your home. The funding later was taken up by Motorola, which was the lead founder in the Series B and C, and again, a strategic investor. And a product launch in '97 with field trials. We've done some field trials in San Diego area. But due to the market industry shift in '98, the digital set-tops started to proliferate in the sense that the operators shifted their point of view, and they felt that they want to keep using digital set-tops instead of point of entry, and our business model essentially collapsed. So what do we do? In 1999, we had to make a choice, either close shop and call it quits. A lot of money would have lost, investors would have lost, or exploit the technology in other ways. Fortunately, we did the latter. And the latter was based on the concept that the technology we developed had a lot of inventions in it. And the robust use of continuations, which allows you to use the same patent disclosure that you already filed and appropriate more compensation for it through looking at claims that actually claim things you haven't claimed before, but they're really not novel in your disclosure. And that was an essential way to breathe new lease of life for the company. These patent disclosures were rich with a lot of enabling material. We were able to file continuations using a different part of the solution. A lot of these disclosures involved several inventions. We just didn't claim the other inventions originally because we were focusing on the customer premise equipment. That we moved to a different direction, and that is the digital video and cable modem data transmission from the cable head ends and a DOCSIS, what is called DOCSIS transmission. A lot of you have cable modems, have essentially that technology as a device in the house. So in 2004 and 2005, the company participated in the standards of the DOCSIS 3.0. We prevailed in terms of our specification was actually adopted by Cable Labs for that particular part of the standard. And as a result, our technology was much more valuable at that point. And in 2005, Motorola bought the company. So that was only because we were able to make that shift. So the important lessons are the essential feature of the U.S. patent system and that is best matched for a shortening technology life cycle that we see. And it does require an ability to have the patent protection for it, ability to match patent claims to actual products in the field, and have flexible business model. No other patent system in the world provides that. Only the US system does. However, we have a shift in claim construction law in the US, which also contribute to aspects of claim erosion in terms of scope. And I have a slide for that, but I'm not going to get into it here. But in general, that is something you need to track. So our companies, Provident Innovation's ability to stay in business and prevent large investor losses was largely due to the agility of the patent system. We would not have survived in Europe, for example. We would have lost everything. And the continuations was the key, and that is it would basically give us the ability to change the claims and essentially reap the benefits for the disclosure that we had to get the right claims later on to cover the right patents, right products. In Europe, our patent applications and international applications were worthless because we have the original claims for the device inside of the house, didn't really claim other aspects of the inventions, and it was too late to do it in Europe. You couldn't do continuations. Now, in 2007, the Patent Office came with a brilliant idea that they're going to curtail the continuation. So naturally, you can imagine my participation and advocacy against that change, and we prevailed in 2007. The case is known as the TAFIS v. USPTO. I've written an amicus brief there to help the process, but it seems like the threat's still there. Now, what is really important, and this is the direction that I want to talk to you about now, is the U.S. patent system has a lot of features that are often being candidates to be thrown out in the name of harmonization. Okay? I urge a lot of caution in that area because it's a system that worked better than any other system in the world for 200 years. The important point is the quid pro quo of the patent system. And to preserve that, you need to be able to allow people to actually get useful claims for their disclosures. Here's the dynamics of what happens with patent applications. So for example, you see several curves here. The original patent application where inventors disclose new inventions for the first time is shown in black, and that is essentially a path of a whole bunch of applications being filed at the U.S. Patent Office, and it basically goes up roughly doubling every 14 years. This is the rate at which also number of journals increase in the U.S., doubling every 14 years. And it's essentially the rate of disclosure of new discoveries, new scientific concepts, new inventions. It's a characteristic time doubling every 14 years. But continuation application are shown here at a higher growth rate. They're both exponential because the log scale in the vertical direction means that every straight line is an exponential growth. But a much higher rate of growth for continuations. It doubles every 6.5 years. There are some blips in there for 1995. That was the GATT application process. So the question is, why is there a higher rate of filing continuations? We file more of those, and the answer is, what else could change faster than the number of disclosures that we have? New product introductions. So if you actually see the same curve now, doubling every 6.5 years, you can see announcements for new products and PR Newswire, trademarks, which typically associated with new products, not new disclosure or new technologies, just new products. And so you see again, these are 6.5 years per doubling. And so we actually have an empirical circumstantial evidence that continuations are related to new products introduction. Indeed, why is that happening? In this chart, we see the fraction of patent applications that require a follow-up with continuations, depending on the technology. So we have essentially a life cycle of the technology over here, and as the life cycle is diminished or smaller, we see that there are more RCEs or more continuations necessary for those type of applications. So this kind of shows that it's designed to deal with shorter lifespan. I'm going to pass this chart that talks about the shrinking life cycle of technology, and basically talk about continuation is basically they don't teach new things, but they look for new claims. Product life cycle reduction, exponential growth and new product introduction necessitate more of those claims and are essential for appropriating those returns. Otherwise, we don't get it. What happens? Patents that issue from continuations are longer lived. And you can see here that there are more, the patents that carry to full term in the US come from a family of more applications. There's more continuations. Well, that's not surprising. So what does that mean? That means that we're moving to a direction where we'll have, in 2018, roughly the same number of continuations filed per year. They're going to catch up with original applications. The demand for claims is going to increase. And the reason for that is we have a shorter lifespan for these technologies, and so you'd have very simple concept of bifurcation. Disclosure is longer lived in terms of the value, but claiming certain aspects of your invention would require be done in several installments. So you can see that the useful life of right to exclude, the claims, is actually getting shorter, even though the value of the disclosure still could be 20 years, or even more, I mean, for the inventor. So without being able to actually come back with more claims, we probably will start losing the value of the patent system. Now, we in America have this continuation and continuation in part, and that preserves some of the value and it still enables us to do things. A patent system that doesn't allow that, for example, in Europe, is destined to fail its patent bargain role. And I think we're starting to seeing that already as a trend. This shows the half-life of patents that are issued in the US versus the half-life of patents that are issued in Europe. Over time, you can see that more and more patents are not being renewed in Europe at a higher rate than those that are issued. And what you see is that the half-life of these patent systems are shrinking. And so if a European patent, the median European patent survives now only about 6.5 years, what is it going to do in about 10 years? You think inventors will actually be able to appropriate reasonable period to get returns in their inventions if they can't really change the claims? So the claiming is not a linear process. It's not a situation where you come up with an invention and you know your claims and you go with that, period. No, you modify your product, you discover that there's a new aspect of the product that requires protection. In the States, we can actually come back with a pending application, we can amend and add more claims to file continuations. Can't do it in Europe and other countries. So I think this is essentially an indicator of where a patent system can collapse as a matter of time. Now, we probably haven't heard about this because the authorities in Europe, and the EPO particularly, actually don't like people to patent a lot more. They believe that too many patents is too bad for they need to be able to clear the room for the innovators. Okay? But that's going to be at their peril and at the innovator's peril. And I think we're going to see a big difference in that process. USPTO has preserved its lifetime. It's true that there's an element here of what the renewal fees are. They're more expensive to renew in Europe. So there's an element of that in here. But I have no doubt that part of the shrinkage of the lifetime of European patents has to do with they're just not useful. It happened to me. We paid a lot of money, and those patents didn't do anything for us, whereas the US patents did a lot. That's a big difference. Conclusion. One reason for superiority of our system is that we have this temporal bifurcation between claiming exclusive rights and disclosing them. There are two separate mechanisms in the U.S., and that's the very important feature. Continuations and RCEs is an economic reality. It's shortening technology life cycle and shifts in claim scope. Unfortunately, some patent antagonists still, even in the PTO, are still looking for, they haven't abandoned the desire to curb these additional claiming opportunities. And I hope we don't see a renewal of the 2007 assault on the patent system again. Thank you.
Thanks, Ron. So before we open it up for audience Q&A, I just want to give the panelists a chance to either react to anything that another panelist said or to ask questions of other panelists. So I guess we can go down the line and either say something or pass.
I'm gonna pass.
Yeah, we just get right into Q&A.
All right, cool. So any questions? Yep. Bruce, we will get you a microphone shortly. Yeah,
Thanks.
it takes a few seconds to turn on.
This is for Sean, so I know that's ambiguous.
Which?
I know that's ambiguous, but it'll be clear. Actually, your talk reminded me of a couple of things that some of your colleagues are doing at Michigan State in reInvent Law, Renee and Dan. And, really what the transactions cost problem really is, when I tell people and they say, what do you do for a living? I say, I teach law students. And they say, how can you live with yourself? I said, no, law students are like ticket scalpers. They're there to reduce transactions costs. They're good. And so, instead of looking at changing law, really one of the things is, that they're doing is they're reinventing law. That's the name of their program. And, they focus on technology. So, I thought that, right back here it says George Mason, where innovation is tradition, but Michigan State, I mean, they have a lot of neat stuff, and I, think that, maybe you ought to sort of talk to them, because, they go to legal tech, and you're saying, imagine, if we had something that could help. So LegalZoom for copyright holders, for individual songwriters and musicians and stuff. And so I guess my question for you is, we actually have a couple of those, TuneCore and SongTrust, and so is there something wrong with what they do, or are they sort of, what you imagine that we should be doing on that end to fix the problems that you identified?
Excuse me. Yeah, thanks for the question, and thanks also for the shout out to reInvent Law, which I could have mentioned. There's definitely, they're one of a number of centers where people are really thinking more generally about how all aspects of law can benefit by more intelligent uses of technology. And certainly there are examples, the ones you mentioned, like TuneCore and CD Baby, that do some parts of this. But I don't know of any private service that offers the full sort of one-stop shop solution. They do give some advice, and they help some aspects of the process. But to make, automated registration happen, you need to have some sort of interoperable system. I don't think any one private companies can engineer a patch solution around it, but it'd be much better if the Copyright Office or somebody, said we need to have this and promoted some sort of standard, not necessarily a government-built system, but just said there needs to be this capability. We see this is not a good example, but in healthcare, they tried to do this in medical records, but they made the fatal mistake of not insisting that the records systems actually be interoperable. So that would be a negative example of what to do, but I think there is some role for the government in spurring this. You've seen this also, by the way, in the copyright alert system, where automated enforcement against file sharing, that was something companies were griping about, but they couldn't really get together between the content holders and the the ISPs, and it really took the government to kind of spur them into a room and reach something, which has some promise. But right now it's only available to a certain set of insiders. It'd be nice if that system were opened up.
I actually respond in as the other Sean. So let me suggest some low-tech things, which is that, what I think Sean is also getting at is the education problem. I don't want to speak for you, but, it's that a lot of artists out there, and Brian's example of somebody who was clearly cognizant. Myself as a songwriter, too, I didn't really know what I was doing, but I found those forms and sent in my recordings of my music to get it copyrighted. But most of the other musicians I dealt with at that time, and even to this day, don't really have any clue about it. So the low-tech thing is that, and this can help in our legal education system right now, is I have this entrepreneurial law clinic that I started at UW. A bunch of clinics now are increasingly trying to help artists. And so if law schools can help foster that and work with, a lot of cities have a volunteer lawyers for the arts kind of system that has attorneys also doing some pro bono. There are ways, it's low tech, it's not, maybe sexy in a way, but it can be actually quite effective. The thing is, you have to get that message out there so artists know where they can go to get human advice, not just have access to some automated systems.
Any other questions?
Can you hear me? My question is for our last speaker. You mentioned you had 23 patents. I was wondering, what was the average it took to go through the patent system, and which was the longest, which was the shortest? I presume they were all handled by the same office. And if you noticed any trends that slowed down the process, such as if you filed any around the same time as the business method patents started coming in, and that type of thing. Thank you.
Okay, thank you. The pendency is typically longer than the average pendency that the PTO tells you that now it's about, 2.5, 3 years, but because that average pendency is not for grant, it's for grant and abandonment, so abandonments are faster, and so it's somewhat misleading. To actually get a patent, it takes longer than the average pendency, and a lot of times it was 2 to 3 years. In some cases, it was 7 years, but we didn't have business method patents. We had pretty much communication technology patents, signal processing patents, but it is often important, particularly before you raise your funds, to show that some of these claims are allowed. Investors that we had were strategic investors. They're a little more sophisticated. They could see the patent applications. And they could see that, they're probably going to get these claims allowed. But for less sophisticated investors and people who are less familiar with the technology, it's important to actually get the patents. So in most of our cases, we had one patent issued or before we got our Series B and C, but during Series A, it was just pending application. And that's how we raise money.
I think we have a question from Chris Newman up front.
Thanks. I was intrigued by something that Ron mentioned about the perils of harmonization in the patent arena, which is something I don't know very much about. I'm more familiar with the copyright side, and that's a place where the international, treaty regime is seen usually from an American perspective as tending toward more expansion of copyright, to getting rid of formalities, pushing toward longer copyright terms and so forth. And I'm wondering whether there's a tension there. On the one hand, you're telling us that to some extent, the more we try to emulate the European system, the more we're likely to harm what you regard as important aspects of copyright. Would you, more generally, do you think it's a good thing for the U.S. to try to preserve a certain form of IP exceptionalism and having its own regime, or obviously the other side of it is harmonization we do that because we want other countries to reciprocally protect our rights in their countries. It seems like there's some tension there in terms of, do we want harmonization or do we want exceptionalism? I'm curious to know what people think about that.
Thank you for the question. I think there's this false notion that there is a quid pro quo between the nations on this issue. There is none. We moved to the first to file, didn't change anything. They didn't go with a grace period. even though the grace period that we have here isn't really a true grace period now after the AIA. So harmonization, I call it harmonization, is not really helpful for U.S. Inventors, particularly small business inventors who can't really afford to do much of that. The harmonization mantra, I think, was pretty much played by the larger companies who are already filing in both, internationally and the U.S. But it was really not something that could help in any way. The expertise we have developed over 200 years about a patent system that works for the inventors, around what they do, around how they run the business. The grace period that we have, ability to go and do trade shows, go raise money, go some disclosure, get a year of that, that doesn't exist in other countries. It's not friendly to startups. It's not friendly to the way we raise money, the way we talk to strategic investors, and the disclosures that has to happen about the technology without losing your patent right. It's a concept that is pretty much foreign. Just give you a sense. How many individual inventors get patents in Europe, just as a fraction of the total? We have here now, we're down to about 8% of all U.S. patents are granted to individuals. Anybody knows the number in Europe? 0.6%. So you could see that the system there isn't really designed for the individual, for the small inventor, somebody who can really benefit from it. Large companies, they can get the protection. They're paying a lot more. So I, for one, believe that harmonization in a patent area is not necessary. It's actually counterproductive.
Do we have any other questions? Yep, Jay. And you'll have a mic in a second.
Ron, I found that data that you presented very interesting. So as you know, this renewal data varies a lot by technology. So, in the United States, pharma tends to pay the third maintenance fees, and other sectors don't. So I'm curious what's going on in Europe. So it really sort of makes sense to compare across technologies. Secondly, do you think that your data is affected by, they have annual payments in Europe, whereas ours are every 4 years?
Yeah, there is that. There are two factors. I think when you come to pharma, the number of patents that are involved is a fraction of all the other patents. Is not one that dominates that in the U.S. It's there. It's not there. It's not there. And they're also using a lot of continuations in the pharma. As to every year, the renewal in Europe is every year rather than every 4 years. You would think that in the cumulative sense, the half-life of patent, which is what I show, the half-life would kind of be the same. It's how long you're going to keep it. It's the resolution. So what I show there is half-life, meaning 50% of the patents live longer than the number that you've seen. So in the U.S., it's just a matter of resolution. And you see a lot of them are going beyond the second period and so on. No, I think that the factors are lower maintenance rate in the U.S. That's a factor. But the trend is important. The declining, and whatever the number is, the declining trend of a lifetime versus the steady state of the U.S. or slight rise is not related to the granularity of when you do the renewal. It's a fundamental temporal change in the obsolescence of claims. Obsolescence of claims of European patents is faster than obsolescence of claims in the U.S. Claims in the U.S. are written better match real products in the market, and therefore they survive longer.
Mark? Here, and get a mic in a second.
This is for Brian. So Brian, you've built a business using technology and networked communication, the internet, to benefit artists during an incredibly difficult time for artists grappling with changing business models. I'm curious what you think are some of the challenges and how you've been impacted by piracy and what you see as the future for small artists. Do you see it as bright, or do you think things need to change to make it bright for individual artists?
Well, that's a good question. I wish I had a simple answer for you, and I don't. I can tell you that I built my business model and my technology in a way where it would hopefully decrease the negative effect of piracy for artists. So, for example, if an artist gets paid before the music goes out, then the effect of piracy on the end result of their income is lessened. The risk is a little bit is reduced. And I'm hoping that technologies like my own and business models like my own will continue to help the artists. There was a speaker yesterday, David Lowery, who was saying that ubiquity is really useless for him. It really has no value to him. And I can see that. I mean, and with new artists coming out, I mean, everybody's everywhere, so it's really hard to really stand out. But I do think for younger artists, and also just philosophically, to me, in any generation, the cream rises to the top. You know, the best of the best always ends up rising to the top in the arts world, I think, or at least getting enough recognition. So the combination of this ability to be ubiquitous and to be everywhere, in combination with a mechanism to be able to solicit funds from people, is a very promising, extremely promising outlook for up-and-coming artists and existing artists right now. It's just the execution of it right now is just a little clunky. You know, it's like, how do you put all those moving parts together? To sum up, I think it's very bright, the future, and it does really depend on, well, I'm not sure what it depends on, actually, you know, what it really depends on, but I know that intellectual property is definitely a huge part of it.
Any other questions? So I actually have a question for Sean O'Connor. You were talking about this shell game that gets played where every business needs to appropriate value in what they're doing in order to have a successful business model, and then, you know, businesses with models that don't rely on traditional IP want to reduce their input costs and you know, devalue the IP inputs that they take. But those are still important to their business model and to the value that they're creating by other means that they protect through other ways. And that, I was hoping you could talk a bit about how this plays out in the real world, and in particular with the DMCA notice and takedown system. And I know it's something you've thought a lot about and you've testified about, and so I'd love to hear your thoughts about, you know, how that works and also how it feeds into some of the stories that get told and some of the notions we hear about why intellectual property or why copyright isn't important, and it's something that also relates back to what Lori said on the panel yesterday about some of the debates about intellectual property are really debates about business models, and the forces pushing to weaken intellectual property still have value that they need to appropriate, and they're kind of hiding the ball on their value and trying to reduce their input costs.
Yeah, so thanks for that. And yeah, let me respond to it in terms of two things, content and code, okay? And so we heard David yesterday say, you know, he doesn't like that it's called content anyway. So that was insane. I think he's right about that. That was one of the first rhetorical moves that we all should have perhaps fought back a little more on it. Since I spend as much of my time in kind of working with and thinking about startups as I do with art side things, you know, I'm guilty of it too. I do call a lot of it content. It's an easy word to use for a lot of stuff. Why does David not like that word? I don't want to speak for him, but you know, we've talked about this a bit. I think he made clear yesterday that it commodifies it. okay? It makes it just like generic kind of widgets. It's just stuff. It's like stuff that's just like natural resources that's out there, okay? The other thing that you have going on, and this is going on in the appropriation art debates, right? Literally appropriation art, as I was talking about the carryover versus print. There's also this, we're trying to deconstruct the romantic notion of the artist author, right? That sounds fancy. Those of you who know that debate know exactly what I'm talking about. For those who haven't heard of it, we just mean that this notion of the romantic author is the sort of 19th century construct of somebody who just has this great, incredible genius idea out of whole cloth, operates by themselves in the garret to create this painting, sculpture, whatever. And so, you know, there's a lot of examples now about, well, art is more collaborative these days. Movies take a lot of people to come together. That's all fine. That's true. But what's happening now is you see much more focus on how all art is really theft and derivative. And I'm sure you've heard that. And there's some truth to that. A little, I don't mean theft, but there's a sense in which you're borrowing other themes and memes from art that's gone before. Okay, so that's a great story and that's fine. But what about code? On the slide, I didn't really pull it out explicitly, but I have to wonder how much code is really written entirely from scratch. Who writes code here? Do you write stuff? Do you ever write a program that's completely has nothing, no kernels, no modules from before? All right, well, so maybe I'm wrong about this. Yeah? So, but do you think the majority of code that's out there is completely from scratch? Okay, well, that's true. But if you're in an organization, do you, right. So, okay, so you think most people do then write from scratch? Okay. Yeah.
Okay. Could you give her a mic?
Oh, yeah, that's good. Yeah.
That was not a natural programming language.
Yeah.
Languages now are natural programming languages. APL was not. It's a mathematical language. It's much, much easier to write code from scratch than take someone else's code that's not documented and try and fix it. So most people do try to take code that's already written and try and fix it.
Right. Yeah, that's what I'm getting at. So, Ron, do you want to comment on that? He's probably a better place to.
Yeah, I mean, in my company, we had firmware and code had to be written for a lot of DSP routines and things like that. We often striving and pushing the engineers not to reinvent the wheel, get some modules that are ready, specifically in some of the applications where you need a particular numerical tool or function. FFTs, I mean, you don't write FFTs from scratch. You don't need to. So a lot of things are building blocks that people have written before. But there is an element to what you were saying, and that is that there's a non-recurring engineering just to adapt somebody else's, especially if it's not documented. So well-documented modules get used more often.
So thanks. He said that much better than I could have said it as the non-coder. I have a little bit of junior programming experience, but more of what I'm trying to speak from is experience as an attorney to companies that do software. And my sense, and I think he explained it better, I'm not trying to say there's not new stuff coming out, but the point is that there is a lot of existing stuff that's there and that's used. And the only theme here that I'm trying to make is that it's not so dissimilar from the art side. And so whatever argument you can make about people kind of, using other people's stuff or being derivative of it are really the same on the code side. And so that's what I mean then about the shell game here, is that why are we not talking about that? Why are we not focusing a little more on, what is really going on in code writing and whether that should be protectable in the same way?
Mark?
So this is for Sean O'Connor. It may be a comment, but it's one you can respond to. When you talk about appropriation, I've often thought that appropriation will find a way. People will find a way to appropriate. And it's not always just inefficient when they don't use the statutory mechanisms or they're not unavailable to them. Sometimes their behavior's socially undesirable. So I knew a consultant, a guy who was a consultant for the World Bank, and he'd go around the world explaining intellectual property to people. So he was once explaining intellectual property to some Pashtun tribesmen who made rugs. And they finally said, oh, we get it. Yeah, we protect the secrets of our dye, and if somebody reveals the secret or steals it, we kill them. And in Chris Brigman and Cal Restrilio's study of stand-up comics who enforce their rights and jokes through social norms, they talk somewhat smirkingly, I think, of how sometimes those rights and jokes are enforced by beatdowns in the parking lot. And it leads me to think that, you know, it's not just inefficient sometimes to not have a statutory mechanism or a more formal mechanism. Sometimes it channels people into some really bad behavior.
Well, yeah, I think that's right. I hadn't thought of anything being quite so violent and graphic, but I guess I don't dispute that. But on the, but I will say that, you know, people go through kind of crazy machinations if they can't use some sort of statutory patent or copyright to try to protect their stuff. And so again, none of my clients, I don't think have ever, you know, done anything violent to protect it. But, you know, this is the debate going on over non-compete agreements and things too. The more you make it hard to find, okay, what are the things that are assets that can be protected, then people will try to use these other mechanisms that are suboptimal and may have other negative consequences. Thanks.
Yeah, we have a question over here, and just wait for the mic.
So when you talk about appropriation, does that include fair use?
As an appropriation mechanism, no, because fair use is really where we're saying that there seems to be a prima facie case that somebody has a copyright to something, and then we're going to allow people, we're going to say in certain cases you can use that content, that copyrighted work, for these specific purposes. Now, the interesting thing is when you, under the guise of fair use, I don't mean that in a negative way, I mean maybe it really is a legitimate fair use, then you do fair use to kind of use that as an input, and then you still appropriate your own output. So that's something where I represent a lot of nonprofits too, and so they get into that area of, well, we're educational and nonprofit, and so we get a lot of fair use bandwidth, but then we're going to create stuff that we in fact do sell out the other end. We're not making a profit off it, but think about universities and others that are doing educational materials. Right? So, you know, I don't see fair use as an appropriation mechanism, but it is a way to get a free input. And that's not to denigrate fair use. I'm not trying to say we shouldn't have fair use.
So we have time for one more question if there's any more. If not, we can just end on that note, and we'll take a 15-minute break and come back for the last panel. So thanks, guys.